Now, for the purpose of this chapter, minor means a person who, under the provision of Indian Majorities Act, is deemed not to have attained the majority, which is less than 18 years, and a wife include a woman who has been divorced or has obtained divorce from her husband and has not remarried. So if you go here, the wife also, one correction that I want to make is unable to maintain is also there in section B. So there is no such exception. So maintenance is available only when the person who is dependent is not able to maintain themselves. Now, so what I was saying is wife includes a divorced woman also who is not remarried. Okay, so this is here. So live-in relationship, would that be covered? Because it says wife. I don't think that will be covered here. But let's see, I think there is some Supreme Court judgments also. I'll check that and then we'll see. Any such allowance for the maintenance or the interim maintenance and expenses of proceedings shall be payable from the date of the order, or if so ordered from the date of application for the maintenance or interim maintenance expenses of the proceeding. So it says from where the maintenance amount will be payable. So it says either the date of the order or from the date of the application as ordered. If any person so ordered fails without sufficient cause to comply with the order, any such magistrate may, for every breach of the order, issue a warrant for levying the amount due in the manner provided for levying fines, and may sentence such person for the whole or any part of each month's allowance for maintenance or the interim maintenance and expenses of the proceeding as the case may be, remaining unpaid after the execution of the warrant, to imprisonment for a term which may extend to 1 month or until payment if sooner made. So, one thing is here the payment is for first interim, second maintenance, that is the ultimate aim, and third is the expenses of the proceeding. So these are the three types of payment that can be claimed, and that can be allowed to be paid from the date of the order or from the date of application. It says if there is a fail. So section 3 talks about default. Default के case में what will happen is any magistrate will order the warrant for levying the due amount, and that will be executed in the manner as if you are levying a fine. So levying fine and then sentence such person, which may extend to 1 month, okay, or until the payment is made, provided that no warrant shall be issued for recovery of any amount due under this section unless application be made to the court to levy such amount within a period of 1 year from the date on which it becomes due. So this is a kind of limitation. So for example, if on this date order is made and the order is to pay it on a monthly basis, for example. So you pay this month, this month, this month. The person fails. So the person has to pay on this month, the third installment on this month. The person fails. Then the limitation period is 1 year. So within 1 year, you have to bring the suit. Okay. Provided further that if such person offer to maintain his wife on condition of her living with him, and she refuses to live with him, such magistrate may consider any ground of refusal stated by her and may make an order under this section notwithstanding such offer if he is satisfied that there is just ground for doing so. So there may also be situation that person says that I will maintain my wife provided that she stays with me. In such a situation, the court will consider that why she is not staying. So the court will consider any ground of refusal stated by her and then will make an order. And if the court is satisfied there is a just ground for not staying, then the order will pass accordingly. If the husband has contracted a marriage with another woman or keeps a mistress, it shall be a just ground for the wife to refuse to live with him. So there are some exceptions. So what could be a just ground? For example, the person has remarried, a person keeps a mistress. No wife shall be entitled. to receive an allowance for maintenance or the interim maintenance and the expenses of proceeding as the case may be from her husband under this section if she is living in adultery. This is the exception that the husband will use. If the woman is in the adultery, then there is no maintenance. Or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. So there are three exceptions. They are very important from the pre perspective. One is adultery. Second is sufficient living separately without any reason. And third is mutual consent से separated है. Okay. Then on proof that any wife in whose favor an order has been made under this section is living in adultery or without sufficient reasons she refuses to live with her husband or they are living separately by mutual consent. So this is the about the proof. So you have to give the evidence. So in the section 125, what are important? First, who are entitled to be first, who are entitled to get maintenance. Second, court. Third, you will talk about interim maintenance. Then you will talk about the duration within which interim maintenance to be covered. Sorry, the proceeding should be finished. Then we have uh, time when that should be payment, when the payment should be made. Then default, then certain exceptions. Exception as in when the husband would be, when a wife can live separately. What are the justified grounds? This is remarriage and mistress. When maintenance would not be allowed to the wife, what are the exceptions? Adultery, separation, and mutual consent. Then you give the proof of the same. So that was section 125. Now let's forward to section 126. 126 talks about proceeding under section 125 may be taken against any person in any district. So this is about the okay where he proceeding under one section 25 may be taken against any person in any district. This is about the jurisdiction. This is about the jurisdiction. कि कहाँ होगा jurisdiction? Where he is or where he or his wife resides or where he has last resided with his wife or as the case may be with mother of the illegitimate child. So, for example, if there is an illegitimate child claiming maintenance, then that child will file. So, there are three people. There's a wife, there is child, and there is parents. Now, for example, if the wife has to file. So, for the wife, so it's very clear. She can file where he resides or where his wife resides. So, she can file it anywhere. Like even she can file it anywhere. Now if we talk about children, where he reside or where that person has resided with the mother. For example, the illegitimate child's mother, M, and the husband. So that will be the child's father. So where these two people have resided, the child can file the case there at that place. All the evidence in such proceedings shall be taken in the presence of the person against whom an order for payment of maintenance is proposed to be made, or when his personal attendance is dispensed with in the presence of his pleader, and shall be recorded in the manner prescribed for summon cases. So that can be a pre-question also. Evidence will be taken in the presence, and the procedure is a summon case. So this is another important aspect, provided that the magistrate is satisfied the person against whom an order of payment of maintenance is proposed to be made is willfully avoiding service or willfully neglecting to attend the court, the magistrate may proceed to hear and determine the case ex parte, and any order so made may be set aside for good cause shown on an application made within 3 months from the date thereof, subject to such terms, including terms as to payment of cost to the opposite party as the magistrate may think just and proper. So this is talking about ex parte and vacating that ex parte 3 months time period. Okay, these are section 126 procedure and the cost and the court dealing with the application under section 125 shall have power to make such order as to the cost as may be just. Done. Now section 127 is alteration in an allowance. On proof of a change in circumstances of any person receiving under section 125 a monthly allowance for the maintenance or interim maintenance or ordered under the same section to pay a monthly allowance for the maintenance or interim maintenance to his wife, child, father or mother as the case may be, the magistrate may make such alteration as he thinks fit in allowance for the maintenance or the interim maintenance as the case may be. So this change can be made in anything. It can be in the monthly maintenance, in the interim maintenance, or anything where it appears to the magistrate that in consequence of any decision of a competent civil court, any order made in the section 125 should be cancelled or varied. He shall cancel the order as the case may be, vary the same accordingly. So this can basically be talking about any civil court का matter कौन सा हो सकता है. That can be, for example, under the Marriage Act, some maintenance is awarded. Second, adultery is proved. Third, divorce on the ground of adultery is being given. Anything of that sort which warrants the variation in section 125, where any order has been made under section 125 in favor of a woman who has been divorced by or has been obtained divorce from her husband, the ministry shall, if he satisfied, the woman has after date of such divorce remarried, cancel such order as from the date of her remarriage. The woman has been divorced by her husband and that she has received whether before or after the date of the said order, the whole of the sum which under any customary or personal law applicable to the parties was payable on such divorce, cancel such order in case where such sum was paid before such order from the date on which such order was made. In any other case, from the date of expiry of the period, if any, for which maintenance has been actually paid by the husband to the women. This is applies basically in the Muslims case, where dower, iddat period. I think when the iddat period is being observed, you pay certain sum of the money, under customary because it says no customary or the personal law. It was payable on the divorce. Then you will cancel such order. ठीक the woman has obtained a divorce from husband and that she had voluntarily surrendered her right to maintenance or interim maintenance after her divorce. Then this will be cancelled. At the time of making any decree, generally होता है when two parties go for divorce, they mutually agree कि the husband will give the divorce and wife will not pay him any maintenance. At the time of making any decree for recovery of any maintenance or dowry by any person to whom a monthly allowance for the maintenance and interim maintenance or any of them has been ordered to be paid under Section 125, the civil court shall take into account the sum which has been paid to or recovered by such person as monthly allowance for the maintenance and interim maintenance or any of them as the case may be in pursuance of the said order. So they're just saying कि if you are making a decree for recovery of maintenance dowry, then you just take into account section 125 also. So 127 may alteration can be made when the receiving person's circumstances changes and it appears and there are various situations. First is order of the civil court. Second is the remarriage customary law. So divorce is obtained, the woman has remarried. On the divorce, you get some money under your personal and the customary law, and On the divorce, you voluntarily surrender. So second is divorce. Divorce may be remarried or customary in the personal law, or you surrender your right. And these are the circumstances where the alteration would be made. Now let's go to 128. Enforcement of the order of maintenance. A copy of the order of maintenance or interim maintenance and expenses of the proceeding as the case may be shall be given without payment to the person in whose favor it is made, or to his guardian, if any, or to the person to whom the allowance for the maintenance or the allowance for the interim maintenance and expenses of the proceeding as the case may be is to be paid. And such order may be enforced by any magistrate in any place where the person against whom it is made may be, on such magistrate being satisfied as to the identities of the person and non-payment of the allowance, or as the case may be expensed due. So, enforcement में there are only two things. Any magistrate at any place can enforce it. 129. Okay, so this is how we end the chapter 8. So, sorry, chapter 9. Chapter 9 was maintenance. It has how many sections? From 125 to 128, which are three sections. 125 talks about who are entitled to maintenance, which court will deal with maintenance, what are interim maintenance, when the maintenance can not be allowed, what are the procedure to be followed, and some limitations or the time duration, like the interim to be decided within 60 months, and the fine in default can be, sorry, imprisonment in default will not be more than 1 month. And it also talks about, in case of default, the application to be made within 1 year. Then we have 126, which talks about the procedure. Procedure may we have the jurisdiction where you can file the suit. The procedure would be the summon case or the summary case. It is the, sorry, it is a summons case. And the ex parte proceeding can be made, and to set aside that ex parte you have to file an application within 3 months. Then 127 talks about the alteration in the circumstances. You alter 125 order where we have firstly change in the circumstances of the receiving person because of the order of a civil court. Secondly, divorce may be the women remarried. Secondly, under the customary law she obtains some amount, and thirdly she voluntarily surrenders. These are the things. And then 128 is the enforcement, which can be by any magistrate at any place. Now we start with chapter 10. Chapter 10 is maintenance of public order and tranquility. We'll do it fastly because they are not really important. Let's read quickly. 129. Dispersal of assembly by use of civil force. Any executive magistrate or officer in charge of police station, in the absence of such officer in charge, any police officer not below the rank of sub-inspector may command any unlawful assembly or any assembly of five or more people likely to cause a disturbance of the public peace to disperse, and shall thereupon be duty of the members of such an assembly to disperse accordingly. So this is with respect to unlawful assembly or the assembly of five or more people which are likely to cause disturbance of the public peace. And the power lies with executive magistrate officer in charge. Since they are the executive wing, they are very less chance to ask question in the judiciary exam because we now here deal with judicial magistrate and not the executive magistrate. But let's just read it quickly. If upon being so commanded, any such assembly does not disperse, and if so without being so, or if without being so commanded, it conduct itself in such a manner as to show a determination not to disperse, any executive magistrate or police officer referred to in subsection 1 may proceed to disperse such assembly by force and may require the assistance of any male person not being an officer or member of the armed force and acting as such for the purpose of dispersing such assembly, and if necessary arrest and confine the person who from who form a part of it in order to disperse such assembly, or that they may be punished according to the law. So 129 only talks about the power. The power lies by executive magistrate and officer in charge to disperse any unlawful assembly or assembly of five or more people which may cause a disturbance. Second talks about using of force by these people with the help of any male person to disperse such assembly in two situations where the command has been given to assembly but they do not disperse, and secondly when the command is not being made but By their conduct, they show that they have a determination to not disperse. In the situation, you will use force, and you can also take the assistance of any male person who is not any officer or a member of armed forces. So they are the assisting by the general public. Now we're talking about Section 130, use of armed force to disperse assembly. If any such assembly cannot be otherwise dispersed, and if it is necessary for the public security, that it should be dispersed, the executive magistrate of the highest rank who is present may cause it to disperse by armed force, using the armed force to disperse it. Now executive magistrate से कुछ नहीं हुआ, पुलिस से कुछ नहीं हुआ, police, so फिर you go to armed force. Such magistrate may require any officer in command of any group of persons belonging to the armed force to disperse the assembly with the help of armed force under his command, and to arrest and confine such person forming the part of it as the magistrate may direct, or is made necessary to arrest and confine in order to disperse the assembly or to have them punished according to law. Every such officer of the armed force shall obey such requisition in such manner as he thinks fit, but in so doing he shall use as little force and do as little injury to person and property as may be consistent with dispersing the assembly and arresting. So this is about proportionate force used by आर्म्ड फोर्स बिकॉज जब आर्म नहीं आती है ना तो दे डोंट लुक सिविलियन कौन है उनको सिर्फ पकड़ना होता है नाउ 131 131 talks about when a power of certain armed force officer to disperse assembly. When a public security is manifestly endangered by such assembly and no executive magistrate can be communicated with, any commissioned or the gazetted officer of the armed force may disperse such assembly with the help of armed force under his command, and may arrest and confine any person forming part of it in order to disperse such assembly, or that they may be punished according to law. But if, while he is acting under this section, it becomes practical for him to communicate with an executive magistrate, he shall do so, and shall thenceforth obey the instruction of the magistrate as to whether he shall or shall not continue. Very easy section. So we have seen 129 May, executive magistrate and the officer in charge of police station will take an action to disperse any assembly. But if and they may even use the force if they do not disperse, or they show a determination to not disperse. And if the assembly cannot be dispersed by them and it becomes very necessary in the public security, then they can these people take the help of army. So they will send a requisition to the army under 130. For example, if the executive magistrate is not present and the public security is endangered because of this assembly, then any army officer, any gazetted army officer, any commissioned or gazetted officer who is present at that moment will take the decision himself. The power is ultimately with the executive magistrate, but this is an exception to it. So general rule is executive magistrate has the power to deal with the law and order situation. They are the ones who will send a requisition to the army. But in case the executive magistrate is not available, then in the public security is endangered, then such army or the commissioned gazetted officer will take the action. But if it becomes practicable to communicate with the executive magistrate, he shall do so. Correct? Now we're dealing with section 132. Protection against prosecution for the acts done under preceding section. No prosecution against any person for any act purporting to be done under section 129, 130 or 131 shall be instituted in any criminal court except with the sanction of the central government where such person is an officer or the member of the armed force, with the sanction of the state government in any other case. So if you have to take an action, so the person, so under 129, 130 and 131, we are saying that you can also use force. For example, in the garb of using that force, they commit some offense. Then in such situation, you will take an action against such officers, such person who is acting. So this is just saying that no prosecution. This is like a immunity. So they are just saying that no prosecution will be taken unless the central unless a sanction from the central government has been taken or the state government has been taken. Give based on whose, if it is an officer or armed force, then you take the central government. If it's a police, police comes under the state government, so take the sanction of the state government. No executive magistrate or police officer acting under any of the said section in good faith. No person doing any act. So ये तो है कि how you can take an action. But there are more exceptions. So if they are acting in good faith, okay, any person who is acting in a good faith in compliance with the requisition under 129 and 130. Okay, 129 and 130. So 129 mein we have seen that a male person who is not an officer or an army officer. 130 mein you call an army officer. So no person. So sorry, this is an immunity to any person. No officer of armed forces acting under 131 in good faith. 131 may they take action themselves. No member of armed forces doing an act in obedience to any order which he was bound to obey shall be deemed to have thereby committed an offence. In this section and in the preceding section in the chapter, the expression armed force means military, naval, air force operating as land force, including any other armed force of the unions operating. Officer in relation to the armed force means a person commissioned, gazetted, or in a pay as officer of the armed force and includes a junior commissioned officer, a warrant officer, a petty officer, and a member in relation to armed force means a person in armed force other than any officer. Okay, very easy question section. Now, part B is the public nuisance. So let's just revise quickly. The part A was the unlawful assemblies part. Wait, part A was the unlawful assembly. Unlawful assembly. So we have 129 where the executive magistrate, police officer, and using force. 130 you send a requisition to the army. 131 when the army takes the decision because the executive magistrate was not present. 132 is the immunity to the officers, to the army, to any person, and all the officials who are acting, and you take a sanction. If they are acting in a good faith, they are not liable. Now we'll be starting with 133, public nuisance. Okay, how many sections are there in chapter 10? Chapter 10 has from 130, 129 to 148, 20 sections. Okay. Whenever a district magistrate or a subdivisional magistrate or any other executive magistrate is specially empowered in this behalf by state government on receiving the report of a police officer or other information and on taking such evidence, if any, as he thinks fit, considers that any unlawful obstruction or nuisance should be removed from any public place or from any way, river, or channel which is or may be lawfully used by the public, or that the conduct of any trade or occupation or the keeping of any goods or merchandise is injurious to health or physical comfort of the community, and that in consequence, such trade or occupation should be prohibited or regulated, or such goods or merchandise should be removed, or the keeping thereof be regulated, or that the construction of any building or the disposal of any substance as is likely to occasion conflagration or explosion should be prevented or stopped, that any building, tent, or structure or any tree is in such a condition that is likely to fall and thereby cause injury to the person living or carrying on business in the neighborhood or passing by, and that in consequence the removal, repair, or support of such building, tent, or structure, or the removal or support of such tree is necessary, or that any tank, well, or excavation adjacent to any such way or public place should be fenced in such a manner as to prevent danger arising to the public, or that any dangerous animals should be destroyed, confined, or otherwise disposed of. Such magistrate may make a conditional order requiring the person causing such obstruction or nuisance, or carrying on such trade or occupation, or keeping any such goods or merchandise, or owning possession or controlling such building, tent, structure, substance, tanks, well, or excavation, or owning, possessing such animal or tree within a time to be fixed in the order to remove such obstruction, to desist from carrying on, to remove or regulate such manner as the case may be directed, such trade or occupation, to prevent or stop the construction of such building, to remove, repair, or report such building, tent, structure, or to remove or support such tree, or to fence such tank, well, or excavation, or to destroy, confine, or dispose of such dangerous animal in manner provided in the said order, or if he object to do so, to appear before himself or some other executive magistrate subordinate to him at a time and place to be fixed by the order, and show cause in a manner hereinafter provided, that why the order should not be made absolute, and no order duly made by the magistrate under this section shall be called in question in any civil court. A public place includes also property belonging to state, camping ground, and grounds left unoccupied for sanitary. Okay, in brief, I'll explain this. Now, the power lies with district magistrate, sub-divisional magistrate, or any executive magistrate to remove the nuisance. What is a nuisance? Nuisance has been defined in these six sections. It talks about कि when there is some obstruction you have been placed on a public place, on a way, river, channels, कोई रास्ता है, उस पे कोई obstruction लगा दिया है, some person has done this and this is unlawful, obviously, that is a nuisance. Then some person X doing some trade, I don't know what I mean, but doing some trade on an occupation, कोई सामान खरीदना बेचना कुछ जो injurious है हेल्थ एंड फिजिकल कंफर्ट के लिए, तो उसको या तो प्रोहिबिट कर सकते हैं या रेगुलेट कर सकते हैं, एंड वी कैन ऑल्सो इवन आस्क द पर्सन टू रिमूव द कीपिंग ऑफ दोज गुड्स, कि जो सामान तुमने रखा हुआ है दैट इज हार्मफुल टू द पीपल, या कोई बिल्डिंग कंस्ट्रक्ट कर रहा है एंड उसका जो डिस्पोजल है, उसका जो सामान बिखरा हुआ है, इधर उधर पड़ा हुआ है, इधर रेत का टीला, इधर ईंट के पत्थर और सब रास्ता रोक दिया है, तो दैट कंस्ट्रक्शन ऑफ बिल्डिंग एंड डिस्पोजल इज लाइकली टू ओकेजन, और जिससे भी हो सकता है कि एक्सप्लोजन हो जाए, प्रिवेंट, कुछ टूट जाए, फूट जाए, कुछ ऐसा कुछ है, या कोई ऐसी बिल्डिंग, टेंट या स्ट्रक्चर या पेड़ जो गिरने वाला है, जो पुराने 30 से 35 साल के बंजर हो गए हैं, जिससे इंजरी हो सकती है किसी को, वो सब या तो उनको रिमूव करो या रिपेयर करो या सपोर्ट करो, या कोई टैंक या कोई एक्सकेवेशन साइट है, कोई गड्ढा खुदा हुआ है और यहाँ पे कोई गिर सकती है, कोई बस गिर सकती है पब्लिक प्लेस में, या कोई एनिमल, पता चले रणथंभौर का पार्क है और वहाँ पे शेर घूम रहा है रोड पे, तो उसको डिस्ट्रॉय, कन्फाइन या अदरवाइज डिस्पोज। तो इधर क्या करेंगे ना, कंडीशनल ऑर्डर पास करेंगे सबसे पहले। यू विल आस्क दैट पर्सन कि ये सारे न्यूसेंस को हटाओ, जो भी है, इसको रोकना है, वो रोकना है, तो एक ऑर्डर पास करेंगे। उस ऑर्डर में हम टाइम फिक्स करेंगे और उसको बोलेंगे कि इसको हटाओ, अगर कोई ऑब्स्ट्रक्शन है तो इसी के वही 6 क्लॉज, इसको इन रिस्पेक्ट, इसको इसका जो भी है, अगर कोई बिल्डिंग है तो उसको हटाएंगे, ये है तो उसको रेगुलेट करेंगे, बिल्डिंग है तो उसके सब्सटेंस को डिस्पोजल के लिए अच्छे से बोलेंगे, तो वही ऑर्डर पास करेंगे। ठीक है, और अगर तुम विद इन टाइम फ्रेम नहीं कर पाते हो ऑब्जेक्ट और अपीयर, तो उसको बोलेंगे, अगर तुम ऑब्जेक्ट करते हो तो यू अपीयर बिफोर माई सेल्फ और सम अदर एग्जीक्यूटिव मजिस्ट्रेट, who is subordinate at a time which is fixed in the order and show cause कि why this order should not be made absolute. ठीक है? This can't be questioned in civil court. So this is an exclusive domain of executing magistrate. That's why I'm saying that it won't be asked in the judiciary. Public place की definition दे रखी है. Now let's move forward. 134 talks about service or notification of order. The order shall, if practicable, be served on the person against whom it is made in a manner herein provided for the service of summon. Okay, ये summon कैसे होगा? If such order cannot be so served, it shall be notified by proclamation published in such a manner as the state government may, by rules, direct, and a copy thereof shall be stuck up at such place or place as may be fit as to conveying the information of such person. How will you service? First, either you summon it or second, you publish it. Simple. Move forward. 135. Person to whom order is addressed to obey or show cause. The person against whom such order is made shall perform within the time and in manner specified in the order the act which is directed thereby appear in accordance with such order and show cause against the same. So हमने देखा था 133 में the order was first conditional. It gives you the time, conditional order pass होता है and it gives you the time, within that time you you do the act which has been asked for you. Second, if you want to object to that, then you appear before the executive magistrate and show cause why you wouldn't do it. तो ये सेम है कि पर्सन अगेंस्ट whom the order is addressed तो उसको क्या करना है either you obey it or you show cause it. तो 133 में you make an order, 134 में you make the service of that order, 135 में the duty. ठीक है, ऑर्डर किया, ऑर्डर भेजा, ऑर्डर भेजने के बाद वो इंसान क्या करेगा. Now let's deal with 136. If the person does not perform such act or appears and show cause, he shall be liable to the penalty prescribed in the behalf in section 188 of IPC. Okay? ना तो वो कम परफॉर्म करता है और now he appears. तो उसका consequence क्या है? Section 188. How will you remember it? So order was made in 133. तो इसको ऐसे और ऐसे जोड़ दो तो you become 138. तो 133 के ऑर्डर का उल्टा काम किया, तो उल्टा काम किया तो क्या बना? ये 133 का उल्टा काम किया. हो गया याद? 188. Now let's move forward. 137. Procedure where existence of public right is denied. Where an order is made under section 133 for the purpose of preventing obstruction, nuisance, danger or use of way, अगर कोई भी order मिला है on the appearance before him of the person against whom the order was made, question him as to whether he denies the existence of any public right in respect of the way, river, channel, or place, and if he does so, the magistrate shall, before proceeding under section 138, inquire into the matter. So, if in such inquiry the magistrate finds that there is any reliable evidence in support of such denial, he shall stay the proceeding until the matter of the existence of such right has been decided by the competent court. And if he finds that there is no such evidence, he should proceed as laid down in section 138. A person who has, on being questioned by the magistrate under subsection 1, failed to deny the existence of a public right of the nature therein referred to, or who, having made such denial, has failed to adduce reliable evidence in support thereof, shall not in subsequent proceeding be permitted to make such denial. तो फॉर एग्जाम्पल ऑर्डर पास किया 133 में, उस ऑर्डर में बोला कि ये जो रास्ता है यहाँ पे तुमने ये ढेर जमाया हुआ है, यू हैव टू रिमूव दिस. द पर्सन सेज दिस रोड इज माइन, इज नॉट अ पब्लिक रोड. So basically that person is denying public right. If that person denies the public right, the court will make an inquiry. So if on the inquiry the court finds that there are reliable evidence in support of such denial, then if there are some evidence, reliable evidence exists, then such right will be decided by a competent court. Since a civil matter, a civil court will decide it, not the court, not the executive magistrate. And if finds that there is no such evidence, then they will proceed as per section 138. And if the person fails to deny the right, उसने deny ही नहीं किया right, then they will be prohibited to deny it at a subsequent proceeding. If a person against whom an order under section 133 is made appears and show cause against the order, the magistrate shall take evidence in the matter as in the summons case. If the magistrate is satisfied that the order either as originally made or subject to such notification as he considers necessary is reasonable and proper, the order shall be made absolute without modification or as the case may be with such modification. If the magistrate is not so satisfied, no further proceeding shall be taken in the case. So basically this is with respect to the part 2. So what is part 2? 133 order. Either you act or you show cause. If you do neither, then you have 188. If you appear and you want to object, you say there is no public right. First thing you will say this. So the court will inquire about this and see if there are some reasonable evidence exists and they transfer the case first to the competent court to decide the right, and it will not proceed further. If there is no such denial of the public right, the court will proceed further and inquire into the matter, look at the evidence produced, the other ground on the basis of which the show cause has been given, and make the order absolute. So the order become absolute in 138. On the, or basically here जो 133 का ऑर्डर था उसको आइदर मॉडिफाई किया जाएगा, और कोई ऑब्जेक्ट कर रहा है तो अकॉर्डिंगली मॉडिफाई किया जाएगा. इफ मॉडिफिकेशन नहीं करना है तो उसको एब्सोल्यूट कर देंगे. एक फाइनल ऑर्डर पास किया जाएगा बेस्ड ऑन द एविडेंस. बेसिकली दिस इज एन अपॉर्चुनिटी of being heard given. And once the order is passed by the competent court, the executive magistrate will proceed under the 138 only. Okay. So 133, 134, 135, 135 is 134 is the service of some duty, 136 is the person fails to do so, 137 is public right, and 138 is making a show cause. 139. The magistrate may, for the purpose of an inquiry under section 137 or 138, direct a local investigation to be made by such person as he thinks fit. Summon and examine an expert. तो इंक्वायरी के लिए हम क्या करेंगे, या तो लोकल इन्वेस्टिगेशन ऑर्डर करेंगे या हम एक्सपर्ट की रिपोर्ट ले लेंगे. ठीक है. लोकल इन्वेस्टिगेशन कहाँ होती है? 310 में. Now, where the magistrate directs a local investigation by any person under section 139, magistrate may furnish such person with such written instruction as may seem necessary for his guidance. Declare by him the whole or any part of necessary expenses of the local investigation shall be paid. The report of such person may be read as evidence in the case. Where the magistrate summons and examines an expert under section 139, the magistrate may direct by whom the cost of such summoning and the examination shall be paid. This is just in continuation. So 139 and 140 goes hand in hand. 139 में अगर local investigation order करी है by such person, तो they will give some written direction कि भाई तुम्हें करना क्या है. Some written instruction will be given. ठीक है. And बाय whom, लोकल इन्वेस्टिगेट एक्सपेंसेस कौन पे करेगा, एंड जो रिपोर्ट होगी वो एविडेंस में जाएगी। और मजिस्ट्रेट जो, और अगर एक्सपर्ट की बात करें तो इसमें भी दे कैन डायरेक्ट कि हु विल बेयर द कॉस्ट। ओके, नाउ 141, procedure on order being made absolute and consequence of disobedience. Now we will see if was the order being made absolute under section 136 or 138 में। 136 में और या 138 में जब एब्सोल्यूट हो जाता है, मजिस्ट्रेट शैल गिव नोटिस ऑफ द सेम टू द पर्सन अगेंस्ट whom the order was made and shall further require him to perform the act directed by the order within a time to be fixed in the notice, and inform him that in case of disobedience he shall be liable to the penalty provided by section 188. If such person is not performed within the time fixed, the magistrate may cause it to be performed and may recover the cost of performing it either by the sale of any building, goods or other property removed by his order, or by the distress and sale of any other movable property of such person within or without such magistrate local jurisdiction, and if such property is without such jurisdiction is without such jurisdiction, the order shall authorize its attachment and sale when endorsed by the magistrate within whose local jurisdiction property to be attached is found. No suit shall lie in respect of anything done in good faith under this section. तो 141 में है डिफॉल्ट अगर करते हैं एब्सोल्यूट ऑर्डर का तो पनिशेबल अंडर 188, और उसके बाद जो एग्जीक्यूटिव विंग है वो खुद जाके उस सामान को रिमूव करेगी और उसका जो भी कॉस्ट इनकर्ड होगा उसको उस पर्सन से रिकवर करेगी। एंड नो सूट शैल लाई इन रिस्पेक्ट ऑफ एनीथिंग डन इन गुड फेथ अंडर दिस सेक्शन। और ये हो गई इम्यूनिटी। Injunction pending inquiry. If a magistrate making an order under section 133 consider that immediate measures should be taken to prevent imminent danger or injury of a serious kind to the public, he may issue such an injunction to the person against whom the order was made as is required to obviate or prevent such danger or injury pending the determination of the matter. In default of such person forthwith obeying such injunction, the magistrate may himself use or cause to be used such means as he thinks fit to obviate such danger or to prevent such injury. No suit shall lie in respect of anything done in good faith. Same thing. It is just about the injunction. अगर कोई इमीनिएंट डेंजर को प्रिवेंट करना है तो इंजंक्शन ऑर्डर करेंगे जिससे कि हम डेंजर को ओबिएट या प्रिवेंट कर सकें पेंडिंग द डिटर्मिनेशन ऑफ मैटर। और इसमें अगर डिफॉल्ट होता है तो मजिस्ट्रेट हिमसेल्फ विल यूज means which are fit to obviate such danger, and there is immunity. No suit if anything done in good faith. Okay, now 143. A district magistrate or sub-divisional magistrate or any other executive magistrate empowered by the state government or the district magistrate in this behalf may order any person not to repeat or continue a public nuisance as defined in the IPC or any special or the local law. वार्निंग एक तरह से वो बोल सकते हैं डीएम एसडीएम ईएम डीएम एसडीएम ईएम के पास पावर है कि वो जाके बोल सकते हैं कि भाई ये इसको रिपीट मत करो, पब्लिक न्यूसेंस है ये, और फिर नहीं तो आईपीसी में पनिशेबल होगा तुम। ओके, तो पार्ट बी इज कवर्ड। पार्ट बी इज पब्लिक न्यूसेंस। लेट्स रिवाइज इट फटाफट। सो 133 में ऑर्डर कौन कर सकते हैं? तीन, डीएम ईएम एसडीएम। ऑर्डर फर्स्ट जाएगा कंडीशनल। कंडीशनल में या तो तुम उस एक्ट को कर दो या फिर तुम अपीयर हो जाओ, शो कॉज करो, और ये जो है इसको सिविल कोर्ट में नहीं जाएगा, ये मैटर यहीं पे अटका रहेगा। कुछ न्यूसेंस भी डिफाइंड है उसमें। उसके बाद ये जब ऑर्डर आएगा तो उसकी होगी सर्विस 134 में। सर्विस कैसे होगी, या तो समन की जैसे होगी अम, या फिर कैसे होगी, प्रोक्लेमेशन के थ्रू होगी। सर्विस के बाद ये जो पर्सन है उसके पास ड्यूटी है। ड्यूटी क्या है, या तो तुम एक्ट करो या फिर शो कॉज करो। करेक्ट। नाउ नाउ व्हाट, फिर उसके बाद ओके 133 हो गया, 134 हो गया, 135 हो गया। 136 नहीं करता है कुछ भी, इसका कंटिन्यूएशन है ना, तो पनिशेबल कहाँ होगा, 138 में, 188 में। ठीक है, फिर उसके बाद या तो फिर वो ऑब्जेक्ट करता है पब्लिक राइट के बेसिस की, भाई ये पब्लिक राइट नहीं है तो इसको कॉम्पिटेंट कोर्ट को भेज देंगे एंड दे विल डिसाइड 138। या फिर वो अपीयर होता है शो कॉज के लिए अंडर 138 में, फिर इंक्वायरी करेंगे, ए- सुनेंगे, एविडेंस देखेंगे और उसके बाद ऑर्डर दे देंगे। इंक्वायरी के लिए इफ यू नीड some help, you can order local investigation in 139, या you can take the help of an expert. Local investigation और इसका एक कंटिन्यूएशन है 140, जिसमें लोकल इन्वेस्टिगेशन के लिए रिटन डायरेक्शन देंगे और कॉस्ट डिटरमाइन करेंगे। सेम एक्सपर्ट के लिए कॉस्ट की एक्सपेंसेस डिटरमाइन करेंगे विद इन योर ऑर्डर। ठीक है, हमने इंक्वायरी कर ली, लोकल इन्वेस्टिगेशन कर ली, सब कुछ कर लिया। अब उसके बाद क्या होगा, ये जो ऑर्डर पास हो गया 138 में, बस अब इसको कोई अगर डिफॉल्ट करता है, 138 को डिफॉल्ट करेगा तो हम जाएंगे 141 में। इसमें क्या है, वही 188 और मजिस्ट्रेट खुद उसको बाय यूजिंग एनी मींस नेसेसरी प्रिवेंट करेगा डेंजर को। 142 में क्या है, इंजंक्शन। अगर इमीनिएंट डेंजर को प्रिवेंट करना है तो 142 फॉलो करेंगे एंड 143 इज ओके। 144, 144, now 144 is urgent case of nuisance or apprehended danger।